Hi, this is Sonnie. Now, occasionally I'm asked by people to give presentations to groups. Sometimes it's for CPD or professional development purposes. Sometimes it's just because the information I've got to share might be relevant and useful to a group of people. Now, one of the things that I've found recently is a great way of rehearsing for these presentations is preparing the slides, the PowerPoint presentation that I'll be using, and rehearsing and recording the audio. So I've got a few presentations that I've got that I might start sharing on the New Zealand Wealth and Risk blog and on YouTube. It's not exactly the same as the presentation that I gave in person. Obviously, every presentation has to be calibrated to the audience and there's feedback involved. But I hope it's useful. This presentation is in relation to digital assets. I gave it to a group of lawyers for CPD purposes, and the aim was to talk about digital assets in the context of estate planning or planning for if you're unable to make or communicate decisions and need someone to step in for you. I've tried really hard to make it as practical as possible. If you've got any questions or any feedback, feel free to touch base, but I really do hope that you enjoy this. So my presentation today is about digital assets, and obviously this is relevant to clients who are older, age being the number one risk factor for many issues, including the need for somebody to act as an attorney or executor. But it's relevant to everyone here in the room, no matter how old or how young you are. And I hope you get something out of it that's personally relevant to you, as well as being relevant to your clients today. We live in a world with so many digital assets. It's easy to think of it in terms of social media accounts, whether that be Facebook or Twitter or Pinterest or Instagram or whatever it is that's most popular at the moment. Obviously, a lot of information's held in Google. We have blogs sometimes. We've got our Dropbox accounts, and then we've even got our devices, including our phones and our computers that hold a lot of personal information. But it's not just ephemeral, sort of intangible stuff. There are some assets that actually genuinely have tangible or monetary implications, whether that be cryptocurrency, balances in PayPal accounts, Amazon commitments, or gift cards, or automatic ongoing purchases, subscriptions for that matter. We've got TradeMe as well. And it's really hard to deal with all of them individually. So if there's kind of two messages I want to take out of this, and I'm going to expand on them from this presentation today, is that we need to communicate our wishes in one way or another, and we also need to ensure that our digital assets are accessible in some way to the people we want. I'll provide some practical suggestions soon. But first, I just want to talk about some of the specific services and what you can or can't do in relation to planning for your assets. So I'm going to talk about Dropbox, Facebook, and Google. So Dropbox is in some ways one of the golden standards, I think, for an organization that holds digital assets and how it works with people who have, for example, passed away. Dropbox's terms and conditions make it very clear that all of the assets, including files, photos, media files, what have you, is your stuff, and it refers to it as your stuff in the terms and conditions. There's a very well written, straightforward page titled "How to Access a Dropbox Account of Someone Who's Passed Away," and it basically says is that if you have access to that person's files and you are entitled to it, access away. The issue comes when you can't access those Dropbox and you need to. Dropbox is quite reasonably very careful in those sorts of circumstances, knowing that it needs to be careful of the information it holds for its clients. And so basically you need a court order establishing it was their intent of the deceased person for you to access their files, and Dropbox has to be compelled by law to provide it. So this goes back to making your assets accessible. It's a lot easier to just make the assets accessible for the people who you want to act on your behalf. Facebook is kind of at the other end of the spectrum. That does have some provision for people who have passed away. And it's an interesting side note to think that there will be a time when Facebook actually has more deceased users than live ones. So what you can do is in the settings, which are squirreled away, so you probably have to Google to find out how to access them, you can nominate another Facebook user, a Facebook friend of yours, to be your legacy contact. Now that person, if you do pass away, they can inform Facebook and they can request that your account just be removed wholeheartedly. The other option is that they can effectively memorialize your account. They can write a pinned post for your profile for anyone who visits it to let any visitor know that you've passed away. They can respond to new friend requests on your behalf, and they can update the profile picture and cover photo. But there's so many things that they can't do. They can't log into your account. They can't remove or change past posts or photos. They can't read messages, remove friends, or they can't even add another legacy contact if something were to happen to them. So it's very limited. And the other thing I'd add is that it changes. I've just reviewed this for the purpose of this presentation, and I am certain that the legacy contact conditions are different from when I looked into it a few years ago, and I am absolutely, without a doubt, certain that that will change in the future as well. Google, I don't know whether I'd say it's a middle range between Facebook and Dropbox. But again, even the Google services are pretty limited. Now, it's worth remembering that Google provides a number of different services. I mean, it's just not just your Google account, it's your Gmail, it's your YouTube account. It also includes Google Drive, for instance, which is a service that's very similar to Dropbox. Now, with Google, you can set up an inactive account manager, and with that, you can nominate up to 10 people. And once you've been inactive and you haven't used any of the Google services for a period of, say, 3, 6, 12, 18 months, you can choose that. Google will then nominate these people. They'll have access to some of your data for a period before all the information's deleted. Now, what's interesting is you can't actually specify the data that they can access or the limitations in relation to accessing this data. And the information when you do this is actually really limited. Like, for example, I've set my wife up to be my active account manager, and I don't know what she's actually going to be able to do or access. Is she going to be able to access all of my Gmail accounts? Is she going to be able to access or edit any YouTube comments that I've made, not that I have made any, or anything that's on Google Drive? The documentation is pretty vague, and I would be pretty confident in saying that they don't have access to everything. Who knows what it is, and that will change over time. So it's not an ideal kind of situation to be in. So I think in relation to digital assets, one of the key things is communicating your wishes, and provision in a will is a really good starting point. I think it's valuable in this day and age to have some provision in relation to digital asset legacies, just to make absolutely clear what your intentions are. And this kind of goes back to the Dropbox example. If you did need to get a court order saying that they have to provide that information, having that a provision like this in the will would go some way towards being able to convince Dropbox to provide with the credentials to log in. The one big caveat I would say is I read an article when I was in Australia by a lawyer in Tasmania, and they said that in a will you should include login credentials. I would recommend highly against that. Don't include usernames, passwords, or anything in a will, because that may eventually become a publicly available document. I think it's probably a good idea to document what your wishes are, perhaps more expansively than in the will. There have been times in the past where I've just shot an email while it was fresh in my mind to my wife and to my brother what I'd want to happen. I also, morbid as it is, keep my own kind of letter of wishes, similar to a memorandum of wishes for a trust, that sets out various things about what I'd want to happen if I were to pass away. And in that, I've got a fairly detailed section in relation to what I'd like to happen in relation to my digital assets. I try to make it as clear as possible that I want my wife and my brother to have the same access to any of my accounts that I would have had I been alive, and to exercise their full discretion. Whether and to what extent that will be useful, I don't know, but it might make the difference in some cases. I've also provided some specific wishes in relation to what I want to happen to my blog or the mailing list that I've been building up, or my Twitter account, or photos. For instance, I want photos with other people to be shared with those other people rather than just kind of to disappear. I also provide some breadcrumbs in relation to how to access everything, so that they will be able to do it. And this leads on to what I hope is, if there's anything that you take away from this presentation today, is please consider to start using a password manager. Now, I've got a friend who works in banking security as one of these geeks, and in the organization he worked for, it was a fireable offense to use a USB drive because it was insecure to do so. However, they were encouraged, if not required, to use a password manager such as 1Password or LastPass. These services are very secure. Their bread and butter is to keep your passwords safe. And they use bank technology and hire for doing so. I used LastPass. It has increased the quality of my life substantially. It means that I have passwords for all services like that. They're all unique to every service, and it's very easy to use and to log on. In Chrome, for example, whenever I come in to log into something like TradeMe, I'll have a drop-down box here, and that will provide the credentials, and it's as easy as that. It's not stored anywhere other than in the password manager. It also keeps other useful information like credit card details, so I don't have to keep them with Amazon or TradeMe or whatever. It has useful information such as passport numbers, driver's licenses, all that useful stuff that can be really valuable. You can also make notes that are private or add attachments, which you could actually use as a digital legacy locker if you wanted to. So, if I were to summarize, when it comes to digital assets, make sure that you communicate your wishes. I think it's really valuable to have a provision in a will for that Dropbox sort of scenario. And I think it's also valuable to just spend, and it really doesn't have to take long, like 10, 15 minutes to write out somewhere, whether it's a document that's kept in file, or an email, or in a letter of wishes, what you want to happen specifically to some or all of your accounts. And the other one is just make your digital assets accessible to the people that you want. And if there's anything that I think you should take away from this presentation, is consider, both for yourselves and also for recommending to your clients, to use a password manager like 1Password or LastPass. Thank you.